This case begins with the defendant asking the judge for mercy, but within seconds, that request starts to fall apart. She claims she wants help, says she wants rehab, and insists she's trying to change her life. But the court record tells a very different story. Missed probation meetings, leaving treatment early, new felony arrests while pregnant, drug use, contradictory statements. And now, a judge who has clearly heard enough excuses. What makes this hearing so intense is that every answer seems to create a new problem. Instead of clearing things up, the defendant keeps digging deeper. The judge starts testing every claim, every timeline, every explanation, and what unfolds is a complete credibility collapse in real time. This isn't just about one mistake. It's about repeated chances, broken trust, and whether the court believes rehabilitation is still possible. Watch closely, because by the end of this hearing, the judge delivers a sentence that changes everything. Was justice served, or was this a cry for help ignored too late? Let us know what you think as this courtroom drama unfolds.
Dear Your Honor, I have been in jail since April 29, 2025. I left for rehab because I wanted to come back here and turn myself in.
Let me just stop you real quick right there, because the officer called Santa Maria, and the people at Santa Maria, according to what that officer put in this report, said that you left the facility because you changed your mind. Hang on. Quote, Santa Maria is not the best option for me at this time. Are you saying you did not say that?
I did not say that. She know why I left because I had a warrant for my arrest and I didn't want the police to pick me up. I couldn't go to the DPS and get my ID and stuff. So I was going to come back to Port Arthur, turn myself in, and just go from there. But I didn't leave because I didn't want the help. That's why I found out I was pregnant on March 31st. I found out I was pregnant. I was in that rehab. I left because they wanted me to go to get my ID, and I couldn't go there because I had a warrant out for my arrest.
Okay, so you found out you were pregnant in March.
Yes.
And then you went and committed an evading arrest with a vehicle, a duty on striking an unattended vehicle, and an aggravated assault against a public servant a month later after you found out you were pregnant?
I was on drugs, Your Honor.
While you were pregnant?
Yes. I made the mistake of leaving the rehab, and I got on drugs, and the next few days later I got arrested.
But you said you made the mistake of leaving the rehab, but you said you left the rehab to come and turn yourself in. So you didn't leave the hang on.
Right here, the judge exposes one of the biggest issues in probation violation hearings: consistency. If someone says they left rehab to turn themselves in, but instead picked up new charges days later, the court immediately starts questioning credibility. And once credibility is damaged, every future statement becomes harder to believe. Judges often give people multiple chances when they show honesty and effort. But when timelines don't match and excuses keep shifting, patience disappears quickly. Notice how calm but direct the judge is. She's not yelling, she's dissecting the story piece by piece. That can be far more devastating than anger. And let's be honest, many viewers will ask the same question the judge is asking. If help was truly the goal, why didn't the defendant go straight to court? Was this fear, addiction, or manipulation? Tell us in the comments.
So you didn't leave the rehab to come turn yourself in, because if you had, you would have come straight here and turned yourself in, and you wouldn't have these new offenses.
I had to catch a bus, so I had to go downtown, wait for the bus to come, and in that time, I caught a charge. I don't want to be separated from my baby, Your Honor. This is mine.
So in that time, hold on. So you had left the facility at least by April 17th.
Yes.
And then your new charges were April 29th.
Yes.
So that's 12 days of waiting on a bus and catching a charge.
I didn't have the money, so I got the money together to catch the bus back out here, the Greyhound. And once I got the money, the day I was going downtown, I got arrested for trying to evade the police because I was on drugs. I was scared and I was on drugs.
So all the times that you failed to report to the probation office, March 7th, March 10th, hold on, there was a third one.
March 12th. March 12th.
March 12th, March 13th, March 14th, March 15th, March 16th, March 17th, March 18th, March 19th, March 20th, March 21st, March 22nd, March 23rd, March 24th, March 25th, March 26th, March 27th, March 28th, March 29th, March 30th, March 31st, March 32nd, March 33rd, March 34th, March 35th, March 36th, March 37th, March 38th, March 39th, March 40th, March 41st, March 42nd, March 43rd, March 44th, March 45th, March 46th, March 47th, March 48th, March 49th, March 50th, March 51st, March 52nd, March 53rd, March 54th, March 55th, March 56 April 10th.
I
So,
never knew I had all those dates after the 7th. After the 7th, I thought I was revoked already. After the first time I did report, I thought I had a warrant out for my arrest, and I went to the rehab.
but you talked to the probation officer
I
between
talked to
then,
her on the 7th.
and you talked to her ugly.
I got out of jail in March 6th in Harris County.
Mhm.
I called her that day.
Mm-hmm.
She wanted me to report the next day. I couldn't make it.
Right.
So I guess I talked to her within that week. I don't remember talking to her, but I didn't know that she was giving me more opportunities to report. I would have reported. I thought after the first time that was it.
This moment is painful because it shifts from legal trouble into personal tragedy. The defendant admits continued drug use during pregnancy, and that instantly raises the emotional stakes of the case. Judges aren't only thinking about crimes, they're thinking about public safety, child welfare, and whether someone is capable of making responsible choices right now. When someone asks for treatment, courts do consider that seriously. But treatment requests often carry less weight when they come only after repeated violations or new arrests. Timing matters. Judges want to see effort before consequences arrive, not only after. There's also something deeper here. Addiction can be real and destructive, but accountability still matters. Courts constantly struggle with where compassion ends and responsibility begins. Do you think the system should prioritize rehab first in cases like this? Or does repeated behavior justify prison time?
The reason you probably don't remember all that is because I guess you were using drugs while you were pregnant.
Yes, ma'am.
Yeah.
I didn't know I was pregnant at first, and then I found out.
But then you kept using drugs.
Yeah. I need help, and Santa Maria is a good place, and they'll offer me mental health service, and I have an autoimmune disease that they offer treatment for. Jefferson County hasn't been giving me the medication for it. And since I've been here 2 days. They haven't given me any medication, so my baby can. Yeah, I don't want to say it out loud what it is, but I need the help that Santa Maria offers. I don't want to be separated from my kids any longer. My 3-year-old is with somebody, a friend, and I want to be him to be able to come with me. I want to be able to keep my kids with me and get the help I need mentally and with the drugs.
So where do you actually live?
I live on 1825 17th Street,
What city?
Port Arthur.
So Santa Maria is what, 90 days?
It's up to 6 months, 6 months to 18 months.
It was verified through the Harris County Community Supervision Court Liaison that the program is 6 months.
Yeah.
So where did you get the 6 months to 18 months?
They told me at Santa Maria when I was there, it's up to, you can stay up to 18 months.
Mr. Smith?
Judge, I spoke with Misty Hoffman, who was an assistant DA in Harris County, before they sent her to the Santa Maria program. They were thinking about doing that, and she tried to explain to me what it was, and I explained to her. Our intention was not to keep her on probation, it was to seek a revocation in this case. I think everything that she had said up to this point kind of lends credence to the fact that probation is, she's not going to be successful on probation. I think even today, you can see that she gets, according to the PSI, becomes impatient, easily irritated, argumentative, and confrontational. She's been non-compliant basically since she started in on probation and has made no progress and has no plan. This is the first that we've heard that she even has a residence in Port Arthur.
Now the prosecution steps in, and this is where the case becomes much more dangerous for the defendant. Prosecutors are building a pattern: non-compliance, confrontational behavior, failure to report, no stable plan, and no evidence probation is working. In sentencing hearings, patterns matter more than promises. Anyone can say, "I'm ready to change" in court. What judges often look for is proof: clean tests, completed programs, consistent reporting, stable housing, respectful conduct. If those things are missing, the court may conclude supervision has failed. Listen carefully to how the state frames this, not as one bad decision, but as ongoing refusal to cooperate. That's powerful because it turns the question from what happened into can this person be trusted going forward? That's a much tougher question to answer.
We had no idea that she had any kind of residence in Jefferson County. She didn't have one prior to this, so I don't even know whose house this is.
So here's the thing.
Yes, ma'am.
Talking over people,
Sorry.
being confrontational with your probation officer is not going to get you anywhere. Right?
Yes, ma'am.
So if you have, what's the place in Port Arthur that you have to live?
It's a home. It's a house.
Whose house?
It's my house. I've been renting it
Since when?
since before I got on rehab. I've been using the same address.
Well, but
Before I got probation.
you told probation that you didn't come back here. Hold on, because you were homeless.
I've never been homeless, ma'am.
You said that in the original pre-sentence report.
No, I told her I was at a motel, and she assumed I was homeless, but I'm not homeless.
But originally, when I put you on probation,
I gave y'all 1825 17th Street, which is where I live.
if you had a residence here in Jefferson County and you were on probation here in Jefferson County, then why didn't you come back here when you got out like you were supposed to?
I tried to come back, and I did come back. I didn't report because I thought I had a warrant out. I thought I was revoked already.
So you were just going to wait it out until they came and caught you?
Came to turn myself in, and I got arrested. I was going to turn myself in.
Everything you're saying is conflicting. Because you're.
I'm here. I'm here.
This may be the turning point of the entire hearing. The judge openly says she believes the defendant has told so many lies she can't keep up with them. That statement is devastating in any courtroom. Once a judge believes someone is being dishonest, leniency becomes much less likely. Remember, judges hear excuses every day. They've seen fear, manipulation, addiction, truth, and deception in every form. So when contradictions stack up, homeless or housed, in county or back home, trying to report or avoiding arrest, the court starts reading everything through a lens of distrust. And here's the hard truth. Sometimes people with real problems also tell lies. That mixture can destroy sympathy. What do you think? Is the defendant confused and overwhelmed, or intentionally misleading the court?
Yeah, you're here in custody, and you're just, I think you've told so many lies to everybody that you don't know how to keep up with them.
It's no lie, ma'am. I was in Houston. I came back, and I came back March 7th. I was here. I didn't report. I was on drugs.
So you were already here March 7th.
I was here March 7th. I was here, and then she told me to come in.
So there's no reason on March 7th that you couldn't have, you were talking to her about needed a bus and all this stuff. That was all just lying back then.
No, I was in Harris County. I got here March 6th. She told me to report March 7th.
So if you were here March 7th.
Yes. Y'all know I was on drugs.
Our jail reports to the judge.
Can you please give me the help that I need and let me keep my kids?
I put you on probation in the first place to get the help that you need. I put you on probation. Hang on. I put you on probation for 2 felonies with all the resources we have to help you. And instead of taking advantage of those, you came back, you didn't go ask for help, you just had to show up one time and say, I need help, I'm pregnant, I'm using drugs, I need help. It's easy to say you need help when you've picked up 3 more felonies.
I didn't pick them up, they dismissed them, I only got 1. They dismissed the other ones.
Well, I'm sure that was part of some plea agreement. You still got arrested for 3 felonies, serious felonies. Not just little stuff, not a possession case.
Your Honor, please, I do not want to be a felon. I can't complete
Well,
this.
quit committing felonies.
Yes, ma'am, that's because of the drugs. Then I lost a baby last year. I had a stillborn at 7 months pregnant because of drugs. I need help with the drugs and rehabilitation.
This exchange is blunt, uncomfortable, and brutally honest. The judge's comments about repeated pregnancy and drug use show deep frustration, not just with criminal conduct, but with choices that affect innocent children. Courtrooms can become emotional when judges feel vulnerable people are being harmed by reckless behavior. Then another issue appears: alleged misconduct inside jail. If someone cannot follow rules even while incarcerated and awaiting sentencing, it sends a terrible signal to the court. Judges often think, if structure here isn't changing behavior, why would probation work outside? That's the silent theme of this hearing. Every chance given seems to have been wasted. At this stage, the defendant needed evidence of progress. Instead, the court keeps hearing about new problems. That usually points toward one outcome.
Maybe you need to stop getting pregnant for a while.
Yes, ma'am.
Looks like one of the jail incidents also involved an assault of another inmate and an attempted through a bar of soap and actually hit one of the correctional officers and tried to swing on one of the other correctional officers.
That is okay.
What
I
that?
never tried to assault a correction officer at this time.
No.
Like jail, prison time, and no.
Let me take a. So why did you refuse to go to the hospital when you fell?
Because I was feeling okay, and I had a doctor's appointment coming up. I was going to tell her. The last time I told them I slipped and fell, they didn't do anything in the jail, so I was going to wait till I go to my doctor's appointment.
But they wanted you to go to the hospital to get checked out.
I didn't know they wanted me to go to the hospital. They just had me sitting in the infirmary.
So. You supposedly said you fell, you were refusing to go to the hospital. They told you the doctor wanted you to go to the hospital. You said that you would go, but asked if you could go back to your dorm first. And they said, we're not doing all that back and forth. You asked if you would be transported via van or EMS. They said, don't worry about that. Then you said, I refuse, I'm not going to the hospital.
That's when I went, I talked to Dr. Kim. Dr. Kim told me whatever was wrong, I could tell the doctor when I went to the doctor. So that's what I was waiting on.
So they're making it up that doctor wanted you to go to the hospital.
They wanted me to go, and I told them I was going to wait until.
But that makes me, you're not taking care of yourself and your baby.
My baby is fine.
How do you know? If you fell and hit your head and they wanted you to go get checked out at the hospital, then how do you know she's fine or he's fine? You don't know.
No.
The judge asks the defendant to sit down, and that usually means the decision has already been made. At this point, judges summarize the reasons for sentencing: dishonesty, danger to self, danger to others, repeated violations, and failed opportunities for treatment. It's not one sentence or one outburst causing the punishment. It's the total picture. Notice how the court also mentions the unborn child and prior pregnancy loss. That tells you the judge sees this case through both a criminal lens and a human lens. She appears genuinely concerned, but concern does not always equal leniency. Sometimes concern leads to incarceration if the court believes freedom creates more risk. This is where many hearings end emotionally. The defendant wants one more chance. The judge believes too many chances were already given.
I don't know what I'm going to do. Go sit down for a minute. All right, Miss Butcher. Sorry we made you wait so long. I hear that you were a little disappointed in that in the back.
I'm scared. I'm never been in prison.
Yeah, well, based on everything that I've already said, based on the fact that you stood here and told different stories about every single thing you said, based on the fact that you've already lost a baby and you're lucky you didn't lose this one, and who knows what's going to happen with this one because you were using drugs, based on the fact that you got felonies while you were on a felony probation, based on the fact that this lady here was trying to help you. You already left the place that you were given an opportunity to go to. Does probation have anything else to add, Ms. Kaur?
Judge, just that I'm really concerned about the non-compliances she's had at the jail.
Same.
I'm really concerned about that.
So here's what I'm going to do, Ms. Butcher, in cause number 24, DCCR 1732. I feel like you've given me no choice but to make sure that your child and children are safe and that the community's safe. I'm going to find that you entered your pleas of true to counts 1, 4, 5, 6, and 7 freely and voluntarily. Find those counts true. In 24 DCCR 1732, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1733, I'm going to find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to need that signed. These cases will run concurrently, which means together at the same time.
Why would you separate me from my kids?
You separated yourself from your
This
kid.
is my first time being in prison.
Let me tell you,
I've been in jail
listen,
4 months.
I got 10 more years I can add. Hold on. You're not going anywhere. Hold on. You're not
That's
done.
not right.
I'm
10
handing you the trial court
No
certification.
chance.
You had chances. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Rojas about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. You need to sign that, and I'll give you a copy of it. If you had showed me that you could behave in our jail, there might have been some other things that I would consider, but
Thank you.
In the end, the judge sentenced the defendant to 10 years for burglary of a habitation and 2 years for unauthorized use of a vehicle, to run concurrently, meaning at the same time. The court made it clear this wasn't just punishment for one offense. It was the result of repeated probation failures, conflicting statements, new felony arrests, drug use during pregnancy, and behavior that convinced the judge supervision had failed. This case highlights one of the toughest realities in criminal justice. Courts may want rehabilitation, but they also require honesty, compliance, and effort. When those elements disappear, prison becomes the consequence. Now we want to hear from you. Was this sentence fair, or should rehab have been prioritized one last time? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.